It is Pride Month, and we are discussing court cases and legislation that has either given or taken away basic rights from our LGBTQIA plus siblings. Some of them groundbreaking cases like Onacle versus Sundowner, Sundowner Offshore Services. Let's talk about it. Picture it, 1991, the year after I graduated high school. Joseph Onacle was working for Sundowner Offshore Services on a Chevron USA Inc. oil platform in the Gulf of Mexico. Now, Joseph was employed as a roustabout on an 8-man crew, which included John Lyons, Danny Pippin, and Brandon Johnson. Lyons, the crane operator, and Pippin, the driller, had supervisory authority. They were pretty much supervisors. On several occasions, Onacle was forcibly subjected to sex-related humiliating actions against him by Lyons and Pippin, the supervisors, and Johnson in the presence of the rest of the crew. Onacle was also violated with a bar of soap and was threatened with actual violation, forcible. You know what I'm saying. He complained to his actual supervisor, but they really didn't do anything. The company compliance clerk, the person who's supposed to keep everyone in line, make sure things like this didn't happen, they called him a name suggesting that he was gay. Onacle would eventually quit, okay? Now, I want to note that apparently all the crew members were straight, so presumably their actions were not motivated by sexual desire. Now, Joseph Onacle would go on to file a complaint against Sundowner in the United States District Court for the Eastern District of Louisiana, alleging that he was discriminated against in his employment because of his sex. Relying on earlier precedents, the district court granted summary judgment to Sunflower Offshore Services, Inc., saying Mr. Onacle, a male, has no cause of action under Title VII for harassment by male co-workers, essentially saying that men could not be sexually harassed by other men. So Onacle appealed, and the United States Court of Appeals for the Fifth Circuit agreed with the District Court for the Eastern District of Louisiana. They said the same thing. Men could not be sexually harassed by other men. Now the case goes up to the Supreme Court, and the Supreme Court reverses the lower court's decisions. Now, guess who wrote the decision? Not Ginsburg, not Kennedy, Scalia. Yes, surprisingly, it was Scalia who wrote the decision. How very progressive of him. Who would have thought? Ooh, and guess who concurred with the opinion? Clarence Thomas. I know, they were probably high, but at least they got it right. They made the right decision in reversing the lower court's decision. They remanded the case for further proceedings in accordance with the instructions that a man can be discriminated against by members of the same sex under Title VII. Now, Onacle versus Sundowner Offshore Services set the precedent for analyzing same-sex harassment and sexual harassment without motivation of sexual desire by stating that any discrimination based on sex is actionable if it places the victim in an objectively disadvantageous working condition, regardless of the gender of the victim or the harasser. So what they're really saying is, yes, men can be sexually harassed by other men, regardless of whether there is a sexual attraction there or not. Now, in regards to Onacle's case, it was remanded by the United States Court of Appeals for the Fifth Circuit to the trial court, and the case was settled out of court. Okay. Now, this case had repercussions. On July 15th, the Equal Employment Opportunity Commission determined that employment discrimination based on sexual orientation was illegal under Title VII of the Civil Rights Act of 1964, and they used the Onacle decision as the basis. So it doesn't matter what gender you are, male or female, you can be sexually harassed, and it is covered under Title VII of the Civil Rights Act of 1964.